Mr. President, Madam High Commissioner, Excellencies, ladies and gentlemen. Mr. President, on behalf of my delegation, let me felicitate you upon your assumption of the presidency and offer our support to you in the discharge of your office during your tenure. At the conclusion of Sri Lanka's Universal Periodic Review last November, I informed the working group that we would continue our practice of sharing with the Council our ongoing progress towards peace and normality. We are present here today to share that progress. Though faced with skepticism and even hostile criticism from some quarters, Sri Lanka has continued to engage its interlocutors in a spirit of openness, candor, and constructive dialogue. Let me now briefly address some of the highlights of our achievements. 3¼ years ago, Sri Lanka emerged from a long drawn-out conflict to eliminate terrorism, successfully conducting a humanitarian operation to free a captive population with a view to bringing about lasting stability, peace and prosperity that had eluded our nation's people for nearly 3 decades. In the aftermath of this operation, it was established beyond doubt that the Sri Lankan government was doing its utmost to continue promoting and protecting human rights of all its citizens. The reconstruction, resettlement, rehabilitation, reintegration and reconciliation program demonstrates that Sri Lanka today is well on the path to usher in an era of sustainable development, social progress and durable peace. Reconstruction includes restoration of physical and social infrastructure, strengthening of civil administration, provision of livelihood support and housing. As a result, a 27% growth rate has been recorded in the northern province, the former theatre of conflict, while Sri Lanka's overall gross domestic product recorded around 8% growth in 2011. Unparalleled progress has been made in areas such as the resettlement of internally displaced persons, facilitated by demining. The last batch of IDPs were resettled in their villages in Mullaitivu on 24th of September 2012. The resettlement of the final batch of IDPs marks a day of historic significance as the resettlement is now complete and there are no more IDPs or IDP camps in the island. This makes the achievement reached within a short period of 3 years remarkable when compared with similar situations in other parts of the world. Mr. President, to address issues pertaining to land, the government is in the process of establishing a land commission. The terms of reference of the 4th Land Commission are now being formulated as we speak. This is in accordance with the LLRC recommendations on land return and resettlement. With the termination of military operations and the gradual restoration of normality, the strength of the military in the north has been reduced considerably. Further rationalization of this presence would be considered in line with national security interests. Mr. President, the government is in the process of devising measures to pay compensation to the owners of properties within such areas or provide them with alternate land. I must re-emphasize that the military is in no way engaged in civil administration, which is the sole responsibility of civilian officials. A significant aspect of the resettlement process is demining. The Sri Lankan Army was responsible for demining approximately 75% of the land, which was the largest single area assigned to any of the parties involved in demining and included most of densely mined regions. As of January 2013, about 99% of the areas identified for demining have been cleared and less than 98 square kilometers of territory remains to be cleared. With regard to the rehabilitation and subsequent reintegration of ex-combatants, from approximately 12,000 persons at the inception, as of 15 January 2013, 396 beneficiaries, 378 male and 18 female are undergoing rehabilitation, and 225 are under legal proceedings under judicially mandated custody, remanded or bail. As of 15 January 2013, 11,456, roughly 9,200 male and 2,250 female persons, including 594 former LTT child combatants, soldiers, have been rehabilitated and reintegrated into the society. It must be noted that Sri Lanka has now been delisted by the UN Secretary General from Annex 2 of the UN Security Council Resolution 1612 on children and armed conflict. The working group has adopted the draft conclusions on the situation of children and armed conflict in Sri Lanka on December 19, 2012, thereby closing the dossier on Sri Lanka in the Security Council. A court of inquiry was established by the commander of the Sri Lankan Army to inquire into the observations made by the Lessons Learned and Reconciliation Commission, we call it the LLRC, in its report as to alleged civilian casualties during the final phase of the humanitarian operation and the controversial Channel 4 video footage, irrespective of its authenticity or otherwise. The Court of Inquiry will now proceed to investigate the second part of their mandate, which is to examine the Channel 4 allegations. We will, of course, keep the Council informed of its developments. In relation to the killing of 5 students in Trincomalee and the 17 ACF workers, this was during the conflict period, the police are conducting further investigations guided by a special team of senior prosecutors, specially mandated for the purpose of examining documents and other forensic material that may be useful to conclude the investigations relating to these 2 cases. The Government of Sri Lanka's efforts continue through the relevant agencies to bring finality to the crimes involved in these 2 cases. I am able to announce, Mr. President, that in the case of the 5 students, the Attorney General has instructed the police to commence a non-summary inquiry before judicial authorities. This is a significant development. Thus, this matter may be brought to a conclusion and is concrete evidence of our commitment to accountability. The LLRC recommendations are being implemented by the corresponding implementing agencies under short, medium and long-term goals based on priority considerations within specified time frames. As to the proposed Parliamentary Select Committee, the government is of the view that it is the most appropriate forum on this matter, since constitutional reforms need a 2/3 majority and a broad national consensus. While the government has nominated its representatives to the Parliamentary Select Committee, the nominations of the opposition parties are awaited. Provincial elections are envisaged to be held within the course of this year for the Northern Province, in keeping with the Provincial Council's Elections Act and relevant judicial pronouncements interpreting the provisions of the law. Despite these gains within Sri Lanka, remnants of the terrorist organization remain very active in some countries in the Western Hemisphere, where their proxies are continuing to lobby host governments, opinion makers in the media and elsewhere to undermine the peace and reconciliation process that is ongoing. It is regrettable that some part of the international community has fallen prey to these efforts based on disinformation, outright falsehood and pressure tactics. This has at times resulted in biased and unequal treatment for Sri Lanka. An example of this selective and inequitable process seeking punitive action on Sri Lanka are some efforts in this very council. We believe that resolution number 19/2 on Sri Lanka, which was introduced and adopted at the 19th session of the council on the 22nd of March 2012, was entirely unnecessary, unwarranted and unfair. Moreover, as is already announced in this council and elsewhere, a follow-up draft resolution on Sri Lanka, already circulated I believe, is to be introduced at this session a year after the earlier resolution. We strongly object to any unfair, biased, unprincipled and unjust approach that may be adopted by this Council with regard to the protection and promotion of human rights in Sri Lanka. We are therefore firmly of the view that this Council should not embark upon or encourage either debate on or any country-specific resolution by virtue of a selective process which would run counter to the founding principles of this Council. Doing so will clearly reflect an application of double standards. Mr. President, it is our position that it is the government's primary responsibility to resolve domestic issues. Unwarranted internationalization of such issues would only undermine the local reconciliation process in Sri Lanka, a process that is still ongoing, impacting adversely on the people in the former conflict-affected areas in their efforts to reap the dividends of peace. Targeting Sri Lanka unfairly in this manner would only serve to further polarize the affected parties, particularly considering that there is no imminent threat to the human security of its citizens or to international peace and security. The bona fides and the objectivity of the proponents of action on Sri Lanka may therefore be questioned. Moreover, the subjective selectivity in focusing on Sri Lanka in this manner, a country which has always cooperated and engaged with the United Nations system and the international community, is unacceptable. Sri Lanka is of the view that country-specific action in the Human Rights Council, such as Resolution 19/2, is a selective and arbitrary process which is not governed by objective norms or criteria of any kind. It is our firm belief that it is vitally important for the structures and procedures of multilateral organizations to be uniform and consistent and devoid of any discrimination. Mr. President, in this context, the report of the High Commissioner for Human Rights, titled Advice and Technical Assistance to the Government of Sri Lanka on Promoting Reconciliation and Accountability in Sri Lanka, has been compiled pursuant to Resolution 19/2. This report will be considered later during the session. Comments and observations of the Government of Sri Lanka in general on the High Commissioner's report were forwarded, and our comments in full are placed on the website. In relation to further engagement, it may be recalled that an invitation was extended to the UN High Commissioner for Human Rights in April 2011, almost 2 years, for a country visit. Thereafter, according to a report, she indicated in May 2012 that the visit to Sri Lanka will be undertaken after an advance visit by a team of officials from an office to explore possible areas for cooperation, and I quote, to help prepare the ground for an eventual country visit by the High Commissioner herself, unquote. The High Commissioner expressed her satisfaction with the cooperation extended by the Government of Sri Lanka to her delegation, whose visit in September 2012 was facilitated in close consultation with the UN country office. I myself met the team when they were in Sri Lanka. In granting the team unfettered access, the government acted in the good faith expectation that it would in fact prepare the ground for a visit. Subsequently, the High Commissioner addressed a letter in November 2012 proposing possible areas of technical cooperation between the Government of Sri Lanka and her office. She also chose to introduce a new conditionality, stating that meaningful progress needs to be achieved in areas outlined for technical cooperation before visiting Sri Lanka at some time in the first half of 2013. Thus, it now appears that the team's agenda was purely to collect material for her present report and not to help prepare the ground for a visit. The Government of Sri Lanka's reply in December 2012 was to emphasize that since the implementation of the National Plan of Action and the National Human Rights Action Plan are continuously evolving national processes which were being monitored in order to arrive at a considered opinion on the progress of human rights related issues, that there is no substitute for experiencing at first hand the ground situation. We reiterate, Mr. President, therefore, that a visit by the High Commissioner would be an ideal opportunity to view the developments objectively and holistically, imperative for the discharge of a mandate. Mr. President, we also note that an inordinate amount of attention is paid to Sri Lanka in the High Commissioner's statements within and outside UN forums, whether it be in the UN Security Council or successive sessions of the Human Rights Council, democracy conferences, or merely comments from her on incidents or events in Sri Lanka, ranging from economic migrants to the judiciary. The High Commissioner has had, from around the end of the conflict in May 2009, a regular negative observation to make. Her frequent comments to the media, some unfortunately in close proximity to sessions of the Council, could well have the effect of influencing delegations, especially when there are resolutions contemplated. This runs counter to the detachment, objectivity and impartiality expected from the holder of such an exalted office. Sweeping generalizations using such terms as massive violations of human rights and the constant targeting of Sri Lanka based on unsubstantiated evidence founded on conjecture and supposition only supports the impression of a lack of objectivity. The report to the Council is also very much in similar vein. Very little attention is paid to the significant progress achieved in the post-conflict phase, matters that we placed before the working group in considerable detail during the UPR in particular. However, in contrast, great emphasis is placed on the perceived negatives as they pertain to the Sri Lanka's process of reconciliation. This disproportionate emphasis on the negative to the virtual exclusion of the positive gives the report a skewed and imbalanced character. Mr. President, it would be incorrect to state that we do not engage with the special procedure mechanisms. During the UPR, we placed on record our continuing engagement with these expert mandate holders, an engagement we value. We agree that the special procedures, while being independent, play an important complementary role to the work of the OSHR. Sri Lanka is, however, concerned to note several instances where special procedure mandate holders have not adhered to the code of conduct and have on occasion exceeded their respective mandates. We therefore emphasize the importance of the need for the mandate holders to adhere to the code of conduct as stipulated in executing their respective mandates. A Cabinet memorandum titled Assistance and Protection of Victims of Crime and Witnesses Bill was submitted by the Ministry of Justice and was taken up for policy approval at the Cabinet meeting of the Cabinet of Ministers held on the 7th of February 2013. I'm sure the High Commissioner would be pleased to note that, because every time I met her on the sidelines of the Council, she has emphasized the need for this bill. The bill has now been presented before Cabinet, and it has been now referred to the Attorney General to obtain his views so that the Cabinet of Ministers can take the decision that is needed to be presented to the National Parliament. The government will engage with stakeholders in connection with the implementation of the National Plan of Action for the promotion and protection of human rights. The annual review of the Human Rights Action Plan is underway, with further information being collected from implementing agencies. The progress achieved will be published on the dedicated National Human Rights Action Plan website. On the issue of the removal process of the former Chief Justice, due process has been followed in accordance with the Constitution of Sri Lanka. Article 107, 2 and 3 of the Constitution of Sri Lanka clearly empowers the legislature to initiate the process to remove the Chief Justice. Following a submission of a motion signed by 117 members of Parliament, a Parliament Select Committee was constituted by the Speaker, consisting of government and opposition MPs to investigate issues connected with the allegations made against the former Chief Justice. The report of the Parliamentary Select Committee was submitted to Parliament and the matter was deliberated upon and debated for 2 days, 1 month after submission of the report. That's a cooling off period that is provided in the standing orders of Parliament. Once a resolution to remove the former Chief Justice was passed in Parliament with a 2/3 majority, with a majority of 106 votes, 155 members voting in favor and 49 only against, the required address was made to His Excellency the President. It was only thereafter that the former Chief Justice was removed from that office. A new Chief Justice has been appointed in accordance with the Constitution. Mr. President, in the field of human rights, we have engaged with the Council since its inception in 2006, continuing the practice of active participation in the deliberations of its predecessor, the Commission. We who come before this Council to engage expect that the principles of universality, impartiality, objectivity and non-selectivity, constructive international dialogue and cooperation with a view to enhancing the promotion and protection of human rights, civil, political, economic, social and cultural rights, including the right to development, upon which this body was founded, will be upheld. I reiterate, Mr. President, what I said earlier. In the post-armed conflict era, we have continued our engagement with human rights bodies, acknowledging the interest that they have in the Sri Lankan situation. We have been candid in our discourse, stating the gains we have made as well as the challenges we face. We have put in place structures for discussion and implementation of solutions. However, we are being told that our chosen path is perhaps the wrong one. It is supposedly deficient. We must be lectured to or even taught. We must be instructed by people who know little of our history, culture and socio-political background. Mr. President, from the Ashokan rock edicts of the 3rd century before the Christian era, societies in our region have been guided by values underscoring good governance and human rights. We do not need to be told. We do not need to be taught. These are not culturally relativist arguments, but are values deeply embedded in our social and cultural makeup. In the modern post-colonial phase, we have, as independent and sovereign democracies, undertaken international obligations with regard to human rights. We have democratic constitutional processes in place. We are fully aware of what we need to do domestically and internationally. We participate in discussions with treaty bodies. We participate in the UPR process. We come before this august body in a spirit of openness and candor and discuss issues. Sri Lanka has voluntarily provided information on the various facets of post-conflict development to the international community through the Universal Periodic Review and UN Human Rights Council sessions. Sri Lanka will continue to proactively and voluntarily engage with UN mechanisms, including special procedures, treaty bodies, as it did in the past. In conclusion, Mr. President, even in March 2012, when a resolution was tabled in the Council, which in effect asked us to do what we were already in the process of doing, we continued to engage in the Council. As has been our custom since the inception, we regularly briefed the Council and had discussions with regional and cross-regional groupings represented in this body on the Sri Lankan situation as it evolved. We hosted side events at which our progress was presented and discussed. We had been open and transparent about our successes and also about the challenges we faced. That resolution was, in our opinion, ill-timed, unwarranted, and violative of the ongoing founding principles of the Human Rights Council. We categorically rejected the resolution on a matter of principle. However, we pointed out the negative outcomes of the adoption of the resolution, but notwithstanding our rejection, reiterated our commitment to achieve lasting peace, stability and prosperity for our people. Effective reconciliation based on homegrown solutions is a cornerstone of that policy. We do not wish to adopt a policy of destructive disengagement, but continue with our policy of constructive and open dialogue. We expect our actions to be assessed in their totality, in a spirit of objectivity and impartiality in this Council. Our interlocutors in this body must also take into account the considerable progress made. During the UPR process, for instance, a clear majority of delegations did acknowledge and appreciate the advances we made since 2009. We thank you for that. This only encourages us to do better and is what we consider constructive. However, the focus of some other intrusive initiatives that only emphasize a few areas which need further action are less than constructive, and we consider these unhelpful. These subjective measures based on unsubstantiated assertions aimed at naming and shaming are indicative of a different agenda unrelated to the objectives of this Council. We need time and space, Mr. President, to complete our work, and we are confident that we will be able to deliver for our people and our country. I thank you, Mr. President.